So it's 1 minute past. I hereby welcome you all to Ava's webinar on AI and intellectual property. Me and my colleague Hanna will be presenting for about 45 minutes for giving you an insight in the exciting world of AI and intellectual property. And we will thereafter be glad to answer questions. So if you have any questions during our presentations, please write them in the Q&A or in the chat, and we will be glad to answer them after our presentation. So today we're going to talk about AI and intellectual property. Me and Hanna, we are managing or leading the Ava AI initiative. We at Ava are focusing quite a lot at AI and the impact on our business. We are doing this from 3 different perspectives, both internally, how we can utilize AI in our daily business and to increase the quality of our services and also increase the efficiency in how we are working together. The second one is, of course, how to assist our clients in protecting their AI, both how they utilize AI as such and how they develop different technologies with AI. And then we have the third area that we are going to talk about today. That's how we can protect or how things that are generated by AI can be protected by intellectual property. So that will be the focus area of today's presentation. And the ones presenting is me, Henrik Aurell. I'm a European patent attorney. I've been working at Ava for a long time and are heading our business area within AI, software and communications, and also a part of our AI initiative. And together with me presenting now is my colleague Hanna.
Yes, hi, welcome everybody. So much fun to have so many people here today with us. My name is Hanna Hansson. I work at Ava's Stockholm office. I'm an attorney at law. I have approximately 15 years experience of working with IP. In 2022, I was working as an in-house legal counsel at a computer gaming company. And that is when this, generative AI just exploded. And I really had to start working with it quickly because there is so much within a game that you can generate with AI, such as visuals, code, music, and even voices. And I've continued working with AI here at Ava. And it is really such an interesting time right now. We're at this technology shift, and it's not the first time. I can compare it to when the internet came or when we started with streaming of the music. And what is happening is that we are trying to apply old laws to new technology and new situations. And this is very difficult. So we're really in a time of legal uncertainty at this point. And you can see this shift in technology within our clients as well. Some have come very, very far with incorporating generative AI, and some have even forbidden it. So let's talk a little bit about the best practice right now. And if you could, thank you. Okay, so the worst thing you can do at your company right now would be to actually ignore generative AI. Because one thing that is certain is that there are a lot of people sitting in your organization working with generative AI at this point. And if there are no guidelines or any boundaries, there is quite a legal risk with this. One of the biggest one being quite obvious is that people are unknowingly sharing confidential information, trade secrets, or personal data. Another risk is that by ignoring this question, people are doing it in secret, right? So you're missing out on that whole knowledge sharing of how to use these tools, and I believe that is so important to do right now. Most important thing is that you need to make internal decisions about where do we stand on AI, how do we use it, what tools are we using, and also that you communicate this within the organization. And, you know, depending on what kind of business you're in and how generative AI actually affects you, it could be anything from like a really complicated policy to just some short guidelines. One thing that is important as well at this point is to set up an approval process of using generative AI tools. And there are some key functions that should be involved in this process. IT, of course, they have opinions on IT security issues. And also some of these generative AI tools have a very large energy consumption. And if you're not aware of that, that could lead to costs that you haven't really counted on. And then license responsible. You know, when you enter into this terms of use with the different tools, you enter into a license agreement with them. So it's really important to have a function that, you know, is quite responsible of keeping track of these licenses. Because what you want to avoid is that you have a lot of people signing up for different licenses and just having no cost control. It may become very expensive. And in some cases, you also, you know, you need an enterprise license and not just a personal license to be able to use it for commercial use or at all. Of course, legal is a very important step in the approval process. As I said, you know, all these tools have their own terms of use, and you actually enter into an agreement with them. The terms can be very different depending on the tool, and you really want to have legal looking at certain questions. For one thing, IP rights, which we will talk about here today, but also look how you're allowed to use it and what they can guarantee for liability and confidentiality and so on. So, Henrik.
Yes. Now you have heard me and Hannah say generative AI a couple of times. And I think that's important also to start there. There are a big difference between more traditional AI that's been around for many years and generative AI. At least from an IP perspective, that's a big difference, huge difference between those. And the more traditional AI is systems and models that optimize and automate predefined processes to calculate things and to assist you in making good decisions. However, generative AI, they are creating something new based on a large amount of data. So when we are talking about generative AI and AI generated content in this presentation, we are talking about content in the form of text, sound, images, or code that is created by a person prompting, that is inputting information and sharing information with an AI and getting something out of that, the output, that's the content and also new content made by the generative AI. So what is the problem with that then, you might ask yourself? Okay, yeah, the biggest problem is that, okay, this is this black box dilemma that we often are talking about. We are inserting questions and information to the AI, and then we get some output, but we have no actual knowledge or clue about what is happening within the generative AI system. So we don't know what information the AI has been trained of, and why the output is what it will be. So that's why also we're talking about new material in this sense. So you get some output, and that could be the code or idea, and a big question here is also, okay, is that made by a human or is it made by the AI? That will be a quite important subject for the rest of this presentation, if the content is made by the human or by the AI. So the next thing that I will be talking about here is that, okay, can AI generate patentable inventions? So what if an AI comes up with an innovation? And what am I meaning about that? Yeah, in this sense, I'm talking about that a person sitting in front of his computer and prompting the AI, and the question that I prompt to the AI gives me an output, and that output describes an innovation. And then the questions come up, okay, could that innovation be patented? So not just a data from a more traditional AI, but new content as output from a generative AI. Could that be patented? That's I'm going to focus on for some time here. So to start asking this question, we need to go to the different patent laws. Here is the EPC, the European Patent Convention, but almost all national law within patents are similar to this. And they are focusing on, okay, for an invention to qualify for a patent, it must be novel, have an inventive step, and be industrial applicable. So that's more, okay, defining how the invention, what the invention is, and so on, and how it looks. And the other question is, who can file for a patent? Who has the right to file for a patent? And from the EPC here, it's stated in Article 60 that the right to the European patent shall belong to the inventor or his successor in title. So when looking at the output from the generative AI from a patent perspective, we need to ask ourselves two basic questions. Could the innovation qualify for patent protection and be novel, have an inventive step, and be industrial applicable? That is, could a machine invent something new? That's the first question that we need to look into. And the other question is, okay, who owns the invention? Who is the inventor? And what happens if the AI is the inventor? Then we have some further challenges. So we have these two questions. They have been more or less theoretical questions for a long time and really hard to answer because there were no actual facts on how to answer these questions. But back in 2018 or 19, yeah, something really interesting happened from our perspective, and that was when the Darbus case was filed. The Darbus case, okay, what is this? This is a patent application for a container. That's maybe not that the most interesting part of this application. But if you can see here also, the designation of the inventor has not yet been filed. Okay, the inventor as such has not been identified. And later on also, when the designation of the inventor was filed, it mentioned that, okay, the inventor is Darbus. The invention was autonomously generated by an artificial intelligence. So here is a really interesting case because they are naming the AI as an inventor. So looking further into this, the Darbus case is okay. To stand for, okay, Darbus stands for a device for the autonomous bootstrapping of unified sentience, and it was filed by a US AI researcher called Stephen Fowler, and he and his team has been trying for years to get the Darbus recognized as an inventor for this invention, and also he has been challenging the patent system in many ways to actually get answers from this. And it's quite interesting also that it's quite, yeah, the invention as such is a quite basic food container for food or beverage. So that's also interesting. But to agree in a little bit more to the Darbus case, this case has been ongoing for several years, as I said, since 2018, 2019, and there has been quite a lot of different rulings all over the world with regard to this case. And the first question that has been asked in a lot of these cases is, okay, can an AI contribute to a patentable inventions? That is, okay, can a machine invent something? And there has been quite a clear answer from the patent authorities all over the world saying yes, a machine can invent something. So that's quite a clear yes from all over the world and the different patent authorities. And then the next question to ask yourself is, okay, can an AI be attributed as the inventor, or yeah, can the AI as such be named the inventor? And there also we have gotten a quite clear answer, and that's no. All patent authorities has answered no to that question. And then the third question is a little also very interesting. Okay, can a patent be granted for an invention if an AI has contributed to the innovation process? Okay, here we go in a little bit in between these two questions. And if I said that there had been a clear answer for the first two questions, there is definitely not a clear answer for the third question, because that's a typical consultant or lawyer answer. That's maybe, and that it depends on the country. So there have been different rulings in different locations all over the world. So I will go in and describe some of these rulings and also other input that we have gotten from patent authorities all over the world. To start with the EPC, in the EPC, the outcome of this Daubus case was, okay, a person or a machine is not an inventor within the meaning of the EPC. So here the outcome of the EPC, the actions or case was, okay, no. And they haven't answered the third question. That's the rulings was based on, okay, if an AI or not can be the inventor. So with regard to the EPC, it's a little bit unclear, for the least to say, if it's doable or not. If you, however, go to and prosecute a patent in the US, then the USPTO has actually, based on that, they also said no in the beginning for the Thaler case or the Daubus case, but the USPTO has come with some guidance of, okay, what do a person need to do when prompting an AI to become the inventor? So if I'm sitting in front and prompting the AI, what do I need to do to become the inventor of the output from the generative AI? So they've given some 5 guiding principles with regard to this. So this is valid for the US. And the first thing is, okay, by just using AI, that does not negate a person's contribution as an inventor. So yeah, you can, if you're using AI, you can still become the inventor. However, it's the second guiding principle is that, okay, merely presenting a problem to an AI system is not enough for inventorship, but significant contribution might exist in specific problem-solving prompts. So if you just ask a question, that's not enough. But if you interact and ask specific or really questions that maybe are hinting on the answers and on the area and so on, if you go a little bit more deeper in how you prompt, then the USPTO mentioned, okay, then you might be the inventor for the output. And the third one is that, okay, reducing an invention to practice is merely reducing an invention to practice is insufficient for inventorship, but making significant contributions to the AI output can qualify. Yeah, so just using the output is not enough, but if you take the output, massage it a little bit, and then use it in a reduce it to practice, then that could be enough for you to become the inventor. Fourth one then is developing an essential building block for the invention can be a significant contribution, even if the person did not participate in every step. So yeah, you can take bits and pieces. Some of the parts of the invention can be made by the AI, and some is made by you as the person prompting the AI. That's also, so here is more guidance. And the fifth one is, okay, merely owning or overseeing an AI system does not qualify a person as an inventor without significant contributions to the invention's conception. So, okay, by doing or producing an AI system like OpenAI is using ChatGPT or so, they don't own the output from that generative AI, and you do not become an inventor just by owning an AI system. So that's also really important to have in mind. And the basics for everything here is, okay, these principles forces a focus on that there should be a human person involved in the process. The human person needs to be in the core of a patentable invention. But you can, of course, work with AI and have assistance by a generative AI. So this is, yeah, in some way the US are trying to make it clear. However, I fully understand that there are quite a lot of questions arising from this guidance also. And I think I haven't seen any case yet when they have challenged if you are the inventor or not. But as we all know, this is the US we're talking about, so there most certainly will be in the future, in my opinion at least. Then we go to China. Also here, the Davos case was denied, and there was a crystal clear that the inventor needs to be a human person, and they also did not go into details of, okay, how much do you have to do? They're just relying on the old definition of the inventor. So China is also, and then we have the last country that I will be focusing on. That's the most recent country coming up with a ruling in the Davos case, and that is Germany. And here we have had a really interesting case. This case has been ongoing for quite a long time, and both the applicant and the patent authority in Germany has appealed this case from different aspects. And from the basic, the first ruling was that, okay, that it is a patentable invention, this Davos case, but the AI cannot be named as the inventor. And this case was referred to the federal patent court in Germany, and they came with their rulings now in this summer. And the really interesting thing here is that the Stephen Fowler filed a lot of different auxiliary requests, but actually in one of them is he, as the inventor, named his own names. The inventor is Stephen Fowler, but with the addition, who prompted the artificial intelligence Davos to generate the invention. So he said, okay, I am the inventor due to that I have prompted this generative AI to generate the invention. And the German federal patent court actually thought this was, yeah, this we can approve. So the case was approved in Germany this summer. And what does this actually mean? There have been a lot of discussions afterwards, but this means that in Germany, you can get a patent for an AI-generated invention, and the person who's prompting the AI system can be named the inventor. So just by sitting in a computer and asking any type of questions, you will become the inventor for that invention. So are there any different conditions? Yes, of course. You need to be a human inventor, but also you said that the court said, okay, have a significant influence on the generation of the invention, but also what this significant influence is that, okay, if this generative AI won't do anything unless you prompt it to. So in their opinion, it's you do a significant, you influence the AI significant if you ask any question. That's how they see it, because then you otherwise the AI wouldn't have made any invention. So in other words, okay, if you prompt an AI system with a suitable problem, and this AI system solves that problem by making an invention, the person prompting the AI system will be the inventor, and thereby also can apply for a patent in Germany. So I think this is really interesting, and this is also been discussed from different angles in different countries. And one of the angles is that, okay, what if I change my mind during the process? And if you start by telling that the AI was the inventor, and then you change your mind and say, no, it was me, the human being, prompting the AI that's the inventor, that could be a problem in the other countries. For instance, in the US, there are a big difference between the US perspective and the outcome in Germany. But I think this is a really interesting case that have at least given us some guidance of how to work with this subject matter going forward. And also, I think that this will need to change how patent departments and IP departments work with this subject. So I think that also you need now to change the invention disclosure forms that companies are working with, and to add in those disclosure forms, okay, what tools have you been using, or have you been using a tool? But in many cases, they have at least used some tool. And also, if they have used an AI tool, which prompts or input were used, you need to start keep tracking these two questions, because otherwise this could be challenged in different countries. And also, if you look at these tools, you also need to look at the terms and conditions of the tools. You need to keep track of those from a patent perspective. And also the output, okay, from the generative AI, was that that altered in some way. So this is a lot of new questions that we need to ask the R&D team, and that we as patent attorneys need to keep track of, and that we need to ask the clients and the patent department also. So a lot of interesting things that we need to focus on going forward. So, and by that, I would like to hand over also the word to Hanna to talk about other things that can be generated by the AI.
A lot of other questions.
Yeah.
I'm going to talk a little bit about copyright in relation to AI generated materials. And there are many ways that generative AI is used today. For example, in the marketing departments, where they generate images and text, in advertising, where you can make campaigns much more cost efficient than when they had to set up complete photo shoots. Computer games, I've already given us an example. So what about the copyright to this? Well, the copyright is the expression of an artist's individual and creative efforts. So there has to be a person behind it, because it's only people that can make creative decisions. So who's creating? Is it the AI tool, or is it the person using the AI tool? And this has been sort of a change for about 2 years ago, when generative AI was new. This was rather strict, and it came from the US. And the general opinion was that if generative AI has been used, there is no copyright. And today, this assessment has become a little bit more balanced. And it's about who has done the greater creative input that has ended up with the results. But for it to be the person, it usually requires more than just generating something. And this is when we talk about AI assisted instead of AI generated. So if you are using generative AI in your business, there are some questions that you need to ask. The first one to be, do we need the generated material to be copyrighted? Do we need copyright for it? If so, I would say that you need to set up a process where generative AI is part of the creative process. It is not the whole entire creative process. So if it is important, you really need to do your own work and your own creative input. And I would also say that it's really important nowadays that you document this creative process in case you need to prove that copyrights. The next question is regarding ownership. Actually, in these tools, you can separate the question of ownership from the one of copyright, which is quite strange. But as you say, something that's generated, there is no copyright for it. But still, in some tools' terms of use, they have actually regulated the question of ownership. In some cases, they claim ownership of anything that's generated by the tool. They can have a license to it or other restrictions in use, such as it's not allowed to use commercially. So if ownership is important, I would say it's really important to assess this question while approving tools that you use. Then there's the question of infringing someone else's copyright. And this is very talked about. How big is the risk that you accidentally infringe someone else's right? And I would say for these matters, you really need to use your common sense. And it's so depending on what you're generating and how you deal with it. Because of course, if you're very specific in your prompting and you're very close to someone else's copyright, such as you say, do it in the style of this company or this artist, well, then you have to be more careful and do more amendments with the result to avoid the risk of infringing. At the same time, if you're generating something very generic, I mean, yeah, the risk would be less. And then we come back to the black box problem, right? That we don't know what is happening within this box. We don't know where the result is coming from. So really use your common sense and amend the output to be safe. Now, a very important question as well. How do we protect our own copyright? I talked about this a little bit in the beginning today, that you have to be very careful what you put in a tool. It's called the input. And I talked about the confidential information, trade secrets, and personal data. But of course, it's also you also have to be careful with your copyrighted material. You know, some tools are using your input to train, and it becomes sort of a part of this black box, fragmented in some part. You don't know how they're going to use it. So be careful with that. And also, in some terms of use, there is actually that whatever you put in there, you kind of forfeit the copyright too. So we're back again to reading the terms of use very carefully and approving the tools before inserting anything with copyright. And then there's the matter of how to stop these AI tools from training with your already published material. It can be your website, your content, or a digital product. And There are a few technical measures you can do. For example, monitoring your site for suspicious activity. You can watermark material. But one very important legal action is to actually opt out from scraping and training by adding a clause on your site or on your product. So that is something that you should do sooner or later. Okay, so let's conclude this with things to keep in mind. As I said, it is very important at this time not to ignore this technological shift that we're in. You really have to, make decision and provide guidelines and have it transparent within the organization in order to minimize legal risks and also for knowledge sharing. The approval process is really important. As I mentioned thousands of times just this hour, is that terms of use and terms and conditions, they're your agreement. They're really important. Don't lose track of them because you risk to lose track of your copyright and your ownership. It's also very important with education within an organization, and just that everybody gets a basic understanding of how these tools work and what kind of information you should be very careful with. Protect your own IP. It's always very important. We've given a few examples how to do that. But also, as usual, protect your trademarks. You can register copyright in some countries. Make sure that you have evidence of your creative processes if they're needed as proof later on. And then compliance, of course. We are not going to talk about the AI Act here today because that would need another hour. But that is something, of course, that you have to keep mind of and see if this affects you and if you have to, comply to it by doing certain things in preparation.
Yeah, I think that's really important also. And I think when you talk about the prior bullet, also protect your own IP, is that it will become really important to keep track of your creative and your development process. A lot of when presenting this presentation before to others, they have stated, okay, can't we just, does that matter? Okay, can't I just put myself as the inventor and so on? Yeah, of course you can do that. That's quite easy to trick the system in the beginning. Just add yourself and no patent authority will challenge that. You can just sign the papers and say that you are the inventor or the creator of this content. But I think going forward, I think this, if you don't keep track of that process, it won't be that fun if you end up in a court case, maybe in the US, and sit on the stand, and that the counterpart start asking questions about, okay, how did you invent the invention and so on. So I think this will be an area where patents and copyrights and other IP rights, okay, this is a completely new area where it can be challenged. So I think now also it's a bit maybe in the future when these cases come, but okay, now is the best time to start keep track of how to protect your own IP and the process for developing it. And then the last bullet also with regard to AI strategy, I think it's really important to find a really good way of utilizing this really strong technology to become a better company. So even though we have talked a lot about challenges and legal stuff within this. I think this is really important for your company to find, okay, how should we work with AI to both open up so that we can utilize it, but also utilize it in a safe and secure way. Because that if you don't start using it, okay, then you at least know that you will be behind your competitors. So to have a clear AI strategy of how to utilize this and how to comply with the different guidelines.
And we're here to assist you with all of these tricky questions. So if you're thinking about some of it, just contact me or Henrik.
Yeah. And then that was the last slide for me and Hanna in our presentation, but now we will be really glad to answer any questions or any comments
we have a question here. Let me see here. Given that patent, trademark, and copyright all have the need for a human as part of the creation, do you think that will affect the attraction of registering designs where humans are not a requirement? Will we see an increase? That is a really good question. I haven't really delved into that.
But you need a designer also to register a design. So even though we haven't mentioned, you need to have the designer is also need to be a human
person.
Yeah. So it's similar that applies to design rights, but there haven't been any actual case. There has been some cases with regard to in Czech Republic. They have had some questions with regard to the design cases also, but that case was concluded based on that the prompts was to what would you say, to open, not that specific, so they didn't get any copyright or design rights for that design. Yes. Are there any further questions?
Okay, we have one here. Let me see.
Yeah, with regard to the Dobus case and Australia, I haven't delved into that in details as such, but I think that's also worth going back and forward as the question says here. But they, if I recall correctly, I know that the outcome was that, okay, the applicant didn't try these auxiliary requests that they did in Germany. So there was actually just the final outcome was that no, there needs to be a human, and not any further with that. But there could be some details in the rulings that I haven't read, but the overall decision was in line with that. But a good question. This is.
Any preferred forms of saving the prompt? I would say at this point, from my legal point of view, of course, you need to save it in some kind of, where it's evident with the date, and it couldn't be, just make sure that it is, doesn't look like it's made afterwards, but set up a process. That is the most important thing, I would say, and date it and explain the process.
Yeah, and isn't it similar to what is already today? If you are in a court case with regard to copyright, you need to describe and prove the creative process.
Absolutely.
I think that will be more similar in patents going forward. That when when it comes to a court case, we need to describe much in more detail how we have come up with the invention and so. But this is a really good question, and I also think that the area of this is developing. Except for the Dabus case, there are not any cases that are so clear cut for being and for asking these questions yet. So yeah.
No, we will have to see where we end up. Is this going to be something that is, that we have to do all the time, showing this creative process? We're not sure yet how that's going to work, but it's really an interesting question. And I really think that it's a good idea to set up a process for saving prompts already now.
Yeah. Any other question? No?
Well, if you do have a question later on, you're very welcome to contact us. You can see our contact details over here. Oh, sure. Go ahead.
We await your prompting. There's a question now.
Yeah, no worries. Yeah, I can say a couple of words about that. It is quite different how AI is handled in China compared to both the US and here. In China, they are a little bit more open to copywriting images made by AI. And I believe in these cases, they were able to do the same image on different prompts. Okay, I just got a message that we should read it out loud because everybody can see the question. Okay, the question is, can you say a few words on the 2 copyright cases in China where the creator has gotten rights for images? Yeah. So what they did is they were able to create the same image multiple times, and that was seen as evidence that it was the person that was the creator and not the AI. I would say that would never worked in the US, and unlikely here in the EU. So right now it is very, globally different what is accepted and not. Yeah,
good question. But that's also, how it is now in this area.
Yeah.
Any further questions?
Ooh, that is yours, Henrik. You get to read that.
So I read out the question. Do you see a risk that the concept of novelty can be challenged in the future? In many social medias, I see a flooding of content with generative AI bots, which is sometimes called the death of the internet. Generative AI bots could technically output a flood of inventions sufficiently detailed to describe a plausible invention. The aim from the person prompting this would not necessarily be seek a patent, but the impact would still be that the novelty is no longer approachable. But actually, this is a really good question, and we had a presentation regarding that a couple of months ago when when the Nobel Prizes was mentioned a couple of months ago. Actually, if you, from a novelty perspective, this won't change, because in that discussion we discussed, okay, the PhD when they just create new PhD studies and present them and so on. So from educational or from the university side, they think, okay, this is a huge problem, because they get papers and studies that is not created in a scientific way and not based on facts and so on. But from a patent perspective, the things that I have read so far is that, okay, even though it was hallucinated by an AI, but if it's presented and an inventor can reach it and read it, then it is part of the state of the art. And as long as an inventor can get, okay, insights from these texts, then they can make an invention based on that. So even though it's not, maybe not true or scientifically proven, an AI hallucination is part of the state of the art from a patent perspective. So, but it could be challenged, yeah. If you publish a lot of things, yeah, that could be a problem. Good question. So, for final question here, the final prompt leading to the actual invention is often generated, or at least sorry. The final prompt leading to the actual invention is often generated or at least enhanced by AI, maybe using another model. Does this require achieving of each step in the chain of prompts? We don't know how in detail we will need to prove this in the courts, but I think when applying for a patent, you don't need to prove this. This is later on if it's challenged in a litigation case. But I think that the important thing is here to keep track of the development process. So even if something is enhanced just by AI or generative AI, that won't affect who's the inventor. But from a copyright perspective, I think this could make a difference, Anna.
For which one?
The final prompt. If you freshen up a text or picture by using AI, that could affect
it's a process. I mean, of course it can affect, but you always have to end up, if you want the copyright, you always have to have the human, to have like the creative, being the one leading the creative process. So I would say it's depending on the entire creative process leading to the result, rather than just one step of it. And often that is how it's used in, advertising or marketing, and generative AI is one part of the creative process. I mean, you generate one image in a greater picture, or you generate something, but then you work with it on Photoshop. So very often it is a part of a creative process, and that's really what you have to document.
And then we will have this as a final question now, because we're running out of time. But the last question is here, okay, as you mentioned, an invention made by an AI cannot be granted a patent. is it then to be considered to be in the public domain if in some way made public? And the answer is yes. If invention is made public and then there are no patent application or patent for it, then it's in the public domain. That's also a risk. If you apply for a patent and you are not the inventor, that could become a part of the public domain. So yes to that question. So
Okay.
it's 12:30, and I thank you all for attending mine and Hannah's presentation, and just round off by saying thank you very much.
Thank you very much.